Hello, hi, how are you doing? Hope you're good. Hope you're fine. You're welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. If you're watching for the first time, this is Lawyers Info Hub. You're most welcome. Feel free to subscribe to the channel, join the family. It's a platform where we simplify law concepts, we teach law, we bring in people to share their legal experiences. We are bothered. We want it to be better. We are concerned in you becoming a better lawyer, in you becoming a better student. So today we're looking at subpoenaed witness, how to conduct trial. We have earlier done a video on subpoena. I'm going to link the description to this video on what a subpoena is, the types of subpoena. So today we're looking basically on how to take on a subpoena witness in trial, during trial. Um, so is the person coming to tell the document? Is the person coming to testify? How do you go on with the examination in chief? How do you go on with the cross examination? A lot of people have not had that privilege of uh, examining a subpoena witness. So they wonder, how do I go about it? Now, I've in a subpoena, as you know, is a court someone uh, compelling someone to come and either tender a document or give evidence with respect to a matter. And it is prepared, there's a recipe for subpoena. When you prepare it, you take it, you file it in the court registry, you take it to the judge who signs on it. When the judge signs on the subpoena, you then serve it. You can use the sheriff of court to serve it on the person who you're compelling to come and give evidence. So the type of a subpoena depends on what you want to achieve. If you want someone to come and tender a document, peradventure, for example, where a composite plan was done by maybe the Surveyor General's office, you want the Surveyor General or an officer of the Surveyor General to come and tender the composite plan, or maybe you want just maybe a document from a parastatal, it could be a government parastatal, a private individual to say, come and tender this document you prepared, or this document emanated from you. Then you do the subpoena duces tecum. That will be the heading of your subpoena. Sometimes you see people issue subpoena duces tecum and they don't want the witness to testify. Objections can be raised in this line. So you must know the type of subpoena your issue. And most of the time, most people what they do is they do the subpoena just take come and subpoena add testificandum together, whereby the person beyond tendering the document, the person can also testify. Now, when you serve the person, it will be the subpoena will contain the date of the trial. And when the person is served, the person is compelled by that order of the court in the name of the governor, depending on the court, you know, depending on the court, excuse me. Some other tribunals are in the name of the president. Yeah, if it's a federal high court or a federal court, it's in the name of the president. If it's in the state high court, it is the name of the governor, where you're commanding the person to come to court to appear in respect of that matter, either to tender document or to testify. Now, when the supreme witness is in court, you that is compelling the witness, when the witness comes in court to court, if it's just coming to tender documents, it is subpoena duces tecum. You don't need to put in his witness statement on oath. Now, the rules of court provides procedures on how to go about a subpoena witness. Each of the rules of court has provisions for that. Now, if he's just coming to tender documents, on the day he's coming, he's with the document, he comes to court, he enters the witness box, the introductories are done, which is you ask him his name, address, where's his occupation or designation, and why he hope he knows or we ask him. We hope he knows why he is in court. He will say that yes, I'm in court on the order of the court, based on the subpoena that was served on me. Then he said, he asked him, you know that you're in court with respect to so document or to tender so document. This is just the part of the introductories. The person will say yes. Then the Lord will seek to tender the document, uh, so document. Say the name of the document. The witness will tender, will just like hand over the document to the court, and that ends it. There will not be any cross examination, but they're just tendering a document. But once he wants to testify, he wants to give evidence, he should be subjected to cross examination because the other party will want to test the veracity of this evidence you're stating. You see? So, in for ad testificandum, you file your witness statement on oath. So, depending on the court you are in, look out for the rules of court with respect to the subpoenaed witness. So you file a witness statement on oath for this person. Then, when the person is being sworn in court by the registrar, you then ask to start with the introductories, which is please tell the court your name, address, occupation. You know why you're in court. The person say yes, I'm in court based on a subpoena served on me to come and testify. As the person recall, you deposed to a witness statement on oath on so date. The person will say yes. He said, okay, what do you intend to do with your witness statement on oath? After the person has identified the witness statement, will say, I wish to adopt it as my evidence in this matter. Then, if there are documents, I told you that you can do subpoena ad testificandum and subpoena uh, dues tecum together. So if the person is going to also tender documents, beautiful, and also testify, beautiful, whichever way. If there's a document for the person to tender, the person can tender it. You make reference to the paragraph his witness statement on oath where the document was referred to. Then, if there are no objections by the other parties, you tender it, the court will admit it. Then you now begin to ask the person questions as to how he maybe the document that was tendered, how he arrived at whatever it is in the document is very important. Least I forget, when you are doing the introductions as to name, occupation, and all that, let the person also state his designation. Let the person also state what his qualification. Sometimes, maybe in a matter, maybe you subpoena a medical doctor or someone who has special knowledge in an area. So you need to tell the court your qualifications. The person now state, I am this, I am that, to let the court know who he is and in what capacity he is coming to what testify. It's very, very important. Now, this is you now ask questions as to the explanation of maybe the document the person has tendered, uh, you know, um, and how he arrived at it. If the person maybe conducted a test or did an investigation, you ask questions as to how did you arrive at the report, how did you go about your investigation. These are questions so that it will give weight to whatever evidence the person is stating. Now, if there are no documents the person um, has stated or is to tender, then you adopt the witness statement on oath. Or ask the witness what he or she wants the court to do for him to. The person will state with respect to why he is there, either to take on I want the court to rely on my evidence to do so maybe for the claimant or dependent, depending on who called the witness. I want the court to rely on my evidence which has proved that, or I want the court to rely on my report, if let to my report to which shows that the claimant or the defendant is owing the claimant, or I want the court to rely on my research, which says just let the person state what he or she wants the court to do with respect to his evidence. Then it's now time for cross-examination. Now, if you're a witness or a party, if you're a counsel who will cross-examine a supreme witness. Now, remember I said it's a witness who is supreme witness who is coming to testify, you cross-examine, not the one who is coming to tender a document. Now, your cross-examination should center on one, his qualification, because he's standing there as an expert. He's standing there sometimes as an expert, depending on the field in which this person has called, the party that is calling that witness has called the witness. Even if he's not standing as an expert, your questions should center on the evidence. Many people, doing cross-examination ask 20 questions that are unrelated to why they are there. Sometimes many people feel that the more questions you ask, the more it seems that you're doing well. We have seen lawyers who ask five pertinent questions, which hit the head on the nail, which hit the nail on its head, and which is very important to their case. It's not in the voluminous nature of your cross examination. If it's five questions, 10 questions that are prim and proper, that fits in, that will elicit the truth you're looking for, you ask it. You know, now if there's a document that the witness has tendered, you ask questions as to how the document was produced, or what gave him the formed his opinion, why is it in the document. Just ask questions around that. Then if he's just coming to give evidence, ask questions on his evidence, how he got to know what he knew, or what basis, or what are his qualifications. So these are where you know, target your cross examination. Your cross examination should not be here and there. It should be coordinated. You see, you ask questions that maybe follow each other. It helps the court even in recording. It also helps in assimilation. When you ask questions that are not uncoordinated, it even makes the witness confused. Ask questions that are coordinated. Try in lining up your questions. Try to, you know, make it chronological, in the sense that let it this follow this. You know, it helps you also in also getting answers you need, and also helps the witness to answer properly because it's following each other. Now, so when you're done with the cross examination, the witness, if there is a need for re examination, that will happen. If there is no need for re examination, that witness will be discharged. Now, we've seen instances where a witness is a subpoena to stand a witness, and the witness refuses to come. Now, that's another kettle of fish to compelling to ensure that that witness, understands the import of that subpoena, and to understand that the witness even knows he needs to obey. So all that stuff you can take, that will be another video we'll do on how to ensure that the supreme witness, obeys the orders of court. Because we've seen that a lot of people don't even know the effect of that subpoena and what it entails, and why you should respect and why you should obey it. And often see where people, when they have been subpoenaed to come to court, they say things that become a tainted witness, become an adverse to the party who has subpoenaed them. So it's the law is diverse. The law is you learn each day, but basically, taking on a supreme witness is no different from how you do your normal trial. But you must know how to challenge. This person just coming to tender document, I don't need to cross examine. If this person coming to testify and tender document together, that means they are coming in a twin double form. It's coming to tender document, it's coming to testify. Then I know where to pin my questions, how to ask him the questions, and how to elicit, truths, and to test the veracity of the evidence he or she is giving. Law practice is beautiful if you understand the dynamics, if you understand the steps, if you understand what to do at every point in time. When you don't know about something, asking questions is not a sign of weakness, rather it's a sign of strength, rather it's a sign of a strong person, because you want to know. I know, keep asking questions. If you don't know anything, ask questions. If you don't have an idea of how it works, ask people who knows how it works, and you're better off. You're more knowledgeable. You now know more. Nobody is an island of knowledge. Nobody knows it all. So asking questions, I believe it's not bad. Rather, it shows you want to learn. So we believe in growth. We believe in you empowering yourself, developing yourself, professional development, personal development, to see that you're becoming better each day. So, friends, it's been a wonderful class today. I just hope you learned something on how to conduct trial for a supreme witness, examination in chief, cross examination, and the types of subpoena that we have, and the intricacies surrounding it. If you're here to subscribe, please do hit the subscribe button. Join us. We're moving through in. Been a wonderful growth. My returning subscribers, I thank you. It's been amazing. It's been an amazing time. It's been an amazing time. I really, really, really appreciate it. Thank you for always stopping by to check what is new on the channel, to know what is happening in the channel. It has been an amazing journey, and I thank you for joining me in this journey to make it a reality. We keep sharing content because we believe that growth is important, and that once you stop growing, then you start dying. Yes, ignorance is like darkness, whereby knowledge is like light that illuminates and takes off every ignorance. Do take care of yourself and keep standing strong. Be resilient, and keep getting at it. Keep pushing. One day you look back and say, "Wow, see how far I have come." Thank you very much.